This is part 3 of the lecture on the history of legal issues in special education. My name is Dr. George Giuliani, and we left off the last lecture in part 2 discussing the 1960s, which now lead us obviously into the early 1970s. And again, going back to what we had discussed, at this time there were no laws protecting children with disabilities in the public schools. And what started to happen is parents were starting to fight for the rights of their children with disabilities. And in the early 1970s, we had two very significant court cases that would pave the way for future federal legislation protecting the rights of children with disabilities and their parents. And those two cases are known as Park and Mills. Park is the Park versus the Commonwealth of Pennsylvania case, and Mills is the Mills versus the Board of Education of District of Columbia case. Now, in the Park case, the court ruled that schools may not exclude students who have been classified with mental retardation. One of the things that was happening in the state of Pennsylvania is that students who were students with mental retardation were being excluded from school because of having the classification of mental retardation. But the court went on to go further, and the court mandated that all students with disabilities, all students, not just those with mental retardation, but all students with disabilities must be provided with a free, appropriate public education. Again, a free, appropriate public education, or a FAPE. Now, we have never heard this term before, and as you know, in special education, this will now become a significant term later on in the federal laws. But this idea that being unable to exclude students, as well as providing a free, appropriate public education for all students with disabilities, these would play a fundamental role in the enactment of future federal special education laws. And that's the Park case. Now, in the Mills case, Mills versus the Board of Education of the District of Columbia, in Mills, Washington, D.C. had the practice of suspending, expelling, and even excluding exceptional children from their public schools. And the court held in Mills that no child eligible for a publicly supported education in the District of Columbia public schools shall be excluded from a regular public school assignment. The District of Columbia shall provide to each child of school age a free and suitable publicly supported education, regardless of the degree of the child's mental, physical, or emotional disability or impairment. So in the Park case, we had a free, appropriate public education being mandated, and now in the District of Columbia case, they said that all students with disabilities need to be provided with a free and suitable publicly supported education. Now, in the Mills case, Mills even went one step further, because Mills set forth future guidelines for federal legislation by rejecting the district's argument that the funds were insufficient to educate students with disabilities. See, the court in Mills mandated that students with disabilities receive special education services regardless of the school district's financial capability. The school district in Mills said, we want to help these children out. We think these children need to be helped, but we can't afford this. We can't afford to be able to do it. And the court in Mills said that insufficient resources may not be the basis for exclusion. In a sense, insufficient funding, insufficient resources cannot be the basis for excluding the child with a disability from a public school education. So what we had is we had Park saying free, appropriate public education and no exclusion of children with disabilities from schools. And then we had Mills saying a free and suitable public education for all children with disabilities, and that insufficient resources could not be the basis for exclusion. And all of these principles, all of these concepts would play a very significant role in future federal legislation. Now, the good thing about this is that the word was starting to get out. Park and Mills, these cases were starting to make national headlines. People started to know about it. But ultimately, Park was a Pennsylvania case, and it only applied to Pennsylvania. The other 49 states didn't have to abide by anything going on with Park. And with Mills, we had the same situation. Mills was just a District of Columbia case. So although these cases would play significant roles later on, and although they played very important roles for where they happened, there was nothing federal about them. And we still didn't have a federal special education law specifically designed for children with disabilities. So, Park and Mills, though, would set the stage for the enactment of federal laws to protect the rights of children with disabilities and their parents. And as a result of these cases and other court cases at that time, federal legislation that would impact all of the nation for all individuals with disabilities began to develop in the 1970s. And that will take us to the end of this lecture. This ends part 3. Please go to part 4 of this lecture, and we'll continue from there.